Welcome to One Happy Lawyer, the estate planning podcast.
Welcome to One Happy Lawyer, the estate planning podcast with attorney Dan Krause, founder of Krause Estate Planning and Elder Law Center in Wisconsin. Dan has been practicing estate planning and elder law since 1999 and is a board-certified estate planning law specialist. I'm Lisa Mosbey, and in this episode, we're talking about which assets go through probate in Wisconsin, which ones avoided, and why that distinction matters for families planning ahead. Welcome back, Dan. Thanks for joining me.
Thanks for being with me, Lisa. It's always a pleasure.
And Dan, we touched on probate a little bit in our last episode, but I really want to dig into some of the nuances that you had mentioned. What does probate mean in Wisconsin? That's where we'll start.
So probate in Wisconsin is just the name of a court proceeding that happens after a person dies if there are assets or if there are some things, maybe not even assets, that need to be dealt with legally in order for that person's final affairs to be brought into, a closure.
And is probate different in every state?
As far as I know, probate is different in every state. I know that I know attorneys from around the country that deal with probate and estate planning, and everybody's got different laws that they deal with. The probate is a matter of state law. There is no federal probate statute at all. It's all about state law. So every state is different. So that's a good time to say, if you're watching this and you're outside of Wisconsin, some of the stuff that we talk about is probably not going to apply to you, although many of the things that we talk about are general principles that will be applied in just about every state.
Now, Dan, let's get into the assets that usually end up going through probate. What are they?
Assets that end up in probate in Wisconsin is anything that you don't have another way to transfer after death. So some things get transferred after death. Normally people have beneficiaries on their IRAs or 401ks. If you do have a beneficiary, then that will not go through probate. It just goes according to the contract that you had with your financial firm. Other things that have beneficiaries, sometimes bank accounts will have beneficiaries or insurance policies. Although if these types of financial instruments or assets don't have beneficiaries, then they will go through probate. So it really depends. So if a house, let's say in Wisconsin, is owned by a husband and wife and one of them dies, normally the house will just transfer to the other one and it will not have to go through probate. However, if a house is jointly owned by somebody that's not a husband and wife, or maybe the husband and wife bought the house and only one of their names is on the title, that may have to go through probate in order to transfer to the other one or to transfer to whoever it goes to. So titling of real estate often really affects whether something's going to have to go through probate. In fact, if I could just take another minute on titling of real estate. In Wisconsin and in many other states, we have different ways to title real estate. Real estate can be jointly owned with rights of survivorship. And that means when one person dies, the real estate just transfers to the other person without a probate necessary. But the general default for putting two people on a title, if they're not married, is if you don't say otherwise on the deed, if it doesn't say right in the deed that it's joint with rights of survivorship, then it's considered to be tenants in common. So if two people are on a deed and they're brother and sister, let's say, it's assumed that that property is owned as tenants in common, which means that when one person dies, the property doesn't just go to the other person, it goes to the heirs of the one who died. So then the living person would have to share it with the children or the spouse or whoever was the heir of the first person to die. So that's tenants in common. So you have joint tenancy or tenancy with rights of survivorship. You can have marital property with survivorship interest. You can have tenants in common. In fact, if a married couple wants to, they could write on the deed of their house that says that this property is owned by John and Mary as tenants in common. and then they could get out of that automatic transfer at their death. So it depends. So a lot of what I'm talking about, and probably getting too far into the weeds on this, but anything that is not otherwise transferred with, say, a joint tenancy with rights of survivorship, or maybe you've got a joint tenancy with rights of survivorship and the other person has already died, or maybe you're in the same car, then that's going to have to go through probate because now you don't have a survivor. One interesting thing, and I don't know which states have this or not, but Wisconsin says in order for you to get that property that was either you were a beneficiary on it or maybe you were a joint tenant, in order for you to get that, you have to survive the deceased person by 120 hours, which is 5 days. And I actually had a case that is being appealed to the Supreme Court about this 5-day rule, but it's fairly well established that if you don't survive them by 5 days, you don't get that portion of the property. It has to go as though you have both died at the same time. Did that answer the question? I'm not sure.
It did. It totally answered the question. Yeah, yeah. And so here, but it gave me another question, Dan. So title and beneficiary, both of those features allow assets to pass outside of probate. What other assets pass outside of probate?
Everything is supposed to go through probate, even the pots and pans, okay? But in reality, most times that doesn't happen. You don't put those on the inventory in a probate. The family just comes and takes the pots and pans. Now there are sometimes really big fights over valuable like jewelry or keepsakes. Maybe they're not really valuable to anybody but someone in the family, paintings, jewelry, etc. Those all have to go through probate. In Wisconsin, and every state I think has this, there's a de minimis amount. If you add everything up that's supposed to go through probate, like it doesn't have a beneficiary or it doesn't have a joint owner with rights of survivorship, if you add it all up, it's under $50,000, then there's no probate that's necessary. In fact, the probate courts don't want you in there because they don't want to have to deal with these itty-bitty cases. And so it's up to the family members to get along and to do this according to the law. And unfortunately, if any of them fight about it, they would have to bring a case in the probate court, and then they would have a big fight about that. But the courts don't want to hear fights over less than $50,000 at this point. I think Illinois is $100,000. 50,000 seems to be a low threshold for the other states that I know about, but I'm really only familiar with Wisconsin on that.
And what does it cost to go through probate? I mean, there's probably a reason why a lesser valued estate doesn't need to do that because of the expense.
Interestingly, in Wisconsin, the cost to go through probate, of course, it all depends on whether you hire a professional to help you. Now, sometimes that can lessen the cost, but usually it increases the cost, but makes it go a lot smoother. Typical probate where nobody's fighting is going to cost about 7% of the estate, or probably a minimum of $12,000 to $15,000. That's just to get all the court forms filed and properly done and shepherd the whole thing and do the inventory and notify everybody of all the stuff that's supposed to happen and follow the rules. But I do know other states like Florida and California are notorious for being very, very expensive. Wisconsin attorneys are not allowed to charge a percentage of the assets in the estate, whereas some states, like I believe Florida, that's the only way they can charge. So the attorneys are not going to take cases that are small because they don't get paid enough, and it makes it harder for things to go through court. And they're all going to want the really big cases because they get a huge fee for those kind of cases. Wisconsin, that's not a thing. In fact, it's illegal for the attorneys to charge. But that also means that in Wisconsin, for a small estate, say a $100,000 estate, the attorney fees can take up a really big chunk of that estate. So you just got to be careful about that stuff. Many people try to do the probates themselves, and sometimes they're successful. Sometimes it takes a long time, and sometimes they have to be told by the court, you better hire an attorney because you're messing this up. And that's when we get involved sometimes.
And then how does a will fit into the probate process in Wisconsin?
So if there is a will, that means that somebody has a valid original document. Original document in Wisconsin must be presented to the probate court. That means there's an ink signature on it that was signed by the person that's passed away, and that it was witnessed at the same time that they signed it by two other people. Now, those other people don't have to be Wisconsin residents or anything like that. They do have to be at least 18 years old at the time. And then that can be brought into court. Now, if there's a challenge to the will, you have to bring in both witnesses and try to find out whether there was any undue influence or whether the person had capacity or all of that. So one thing that we do in order to make it so that we don't have to go searching for those witnesses and bringing them into court is Wisconsin allows you to have a self-proving will. So you don't have to have the witnesses in there. And that means that you have to have two witnesses plus a notary. And the notary just essentially notarizes and verifies that the person that signed the will is the person that they say they are, and that the notary also says that the two witnesses signed at the same time. And if you've got all three of those on the will, then it's called a self-proving will, and you don't have to bring in the witnesses. So in order to start a probate case of somebody that had a will, you need to bring the original will into the court. Then you also have to send copies of that will to all the heirs at law, the interested parties. And maybe you wrote somebody out of the will. Let's say you had 4 kids and one of them you feel like you've given enough to them and you don't want them to have anything. Even though they're not mentioned in the will, or maybe the will just says they're disinherited, they still have to be given a copy of the will and invited to object. In fact, they're asked if they will sign a waiver to say, I'm okay with this will being the will that's administered in this court, and I'm okay with this person, not me, being the personal representative. And if they don't sign that, then you have to have a hearing. So part of the will is you have to give copies to everybody. You have to bring the original into court, and then you can't open the probate, or you can't give the personal representative the powers to do what they need to do until the will has been proved up. So once the will's been proved up and any controversies about the will are settled, then the personal representative is appointed, and it's usually the person that's listed in the will to say that they're going to be the personal representative, also known as executor. And then they are given the powers to do all the things that they need to do and report to the court.
And Dan, what are some probate surprises people don't see coming with bank accounts, real estate, retirement accounts, or even other assets?
So some of the problems that we see with probates is, let's say you got mom and dad with 3 kids, and one of the kids moves in with mom and dad later in life, maybe to help take care of mom and dad, and they give up their job and they rely on this place to live because mom and dad are providing the place for them to live. They also don't have any income anymore, so they're relying on mom and dad's income so that they can take care of mom and dad. Dad dies, then mom dies, and now this person's stuck in this house that doesn't belong to them. They can't afford to move, and now their siblings want their share of the house. That's a big surprise, and sometimes it's a really painful thing to deal with. And unfortunately, many people just say, hey, look, we're not going to deal with it. We see probates opened up 20 years after somebody dies because they didn't want to deal with the house. So they leave the house in mom and dad's name. The child just pays the taxes on it, and nobody cares one way or another until one of the children dies. And now it all has to be figured out. And sometimes more than one of the children have died, and you have to retrace who was supposed to get it. We've got a case similar to this where there are several children. Let's just say there are 6 children. Mom died, and then some of the children started dying before there was any kind of a probate going on. So we have to trace back to see who's supposed to get stuff. Because remember, you have to survive by at least 5 days in order to get anything. But if you survive, even though you died after the 5 days, your estate has to get whatever you would have gotten. So now we have to open up a probate for that child because they've died. And the other child. Now we've got 3 probates all going at the same time just to get this house divided up. Sometimes it's a real mess. So that's one of the things that sometimes pops up. Sometimes we
And
go
I
all
go
the way
back to
through
the
a probate.
cost.
It may take a year and a half, and everything's tied up, and you close it out. And then somebody says, oh, there's another account. And so then you have to reopen the probate, or maybe you do a special administration in the probate court to get rid of that one asset. Sometimes those things pop up. This is one thing I don't like about the banks, always wanting you to set up everything digitally, right? You don't get things in the mail. Whenever everybody got the monthly statement from their bank, they got the monthly statement from their investments, it was easy to find the assets because the mail would just come. The person died and their mail would keep coming, and you say, okay, here's all the statements, we know where it is. But when it's digital statements, sometimes that stuff is never discovered until many years later, unfortunately. So those are other surprises. Sometimes sometimes we're able to find those things by doing a credit check of the deceased person. And there's other ways to find assets, but there's no really good guaranteed way to find all the assets.
Dan, if someone wants to understand how their own accounts and property would transfer today, what information should they review first?
Well, they should look at the title to their property, which is on the deed. Now, a lot of people believe wrongly that your property belongs to the bank until you've paid off the mortgage. That's not true, in Wisconsin at least. As soon as you close on the house, even though you owe whatever the house is worth to the bank, the deed is in your name. You are the owner of the real estate. It's just that there's a lien in the form of a mortgage on the house. So you've received a deed, even though you don't have it in your records, or you don't remember, or you don't realize, you have a deed with your name on it that shows that you're the owner of the property. You should have that, and you should look at it. Now, most people don't know what to look at, but if you're married people in Wisconsin and it's a homestead, meaning that you live there, and you bought it during the marriage and both your names are on the deed, that means that if one person dies, the other person just gets it. Now, if any of those things are broken, maybe you got it before the marriage and you weren't married at the time that you bought it, now there's going to be some other issues there. So look at the deed. Maybe it says tenants in common. Maybe only one person's name is on the deed. Sometimes people get the mistaken impression that, well, the husband's name was on it, and then we both moved in, and then we refinanced, and both of our names are on the mortgage, so now we both own the thing. That's not true. It's only who's on the deed, so you got to be careful that don't confuse the mortgage with the deed. The deed is the title instrument, and that's who has title. Bank accounts also can be titled in different ways. So you can have joint bank accounts, and sometimes you can even have joint bank accounts without rights of survivorship. So that means if one person on the bank account dies, then the half of that doesn't go to the other person. It goes to the heirs. So bank accounts can be titled similarly to real estate, so that either they merge with the survivor or they separate at the death of one person.
Excellent. And I think we're going to leave it there for today. This was very detailed and specific. Thank you so much for taking your time to walk us through the process.
Yeah, sorry to get so detailed. Sometimes it just, it gets complicated.
It does. And I think that's what we're letting our audience know, that this isn't something that you necessarily want to tackle on your own. There's so many ways for it to fall through the cracks and land you in probate. And the goal is not to do that.
Right. And just one thing before we go is that if you take on the job of personal representative under somebody else's probate, if you do it wrong, you can be personally liable, and you might have to pull money out of your pocket if you gave it too soon to somebody and there was a claim against the estate. I've seen that happen, where you try to chase beneficiaries to get the money back so that you can actually pay who is supposed to be paid. And you can imagine that some beneficiaries are not really happy or able even to give that money back, and the personal representative can be on the hook. So be careful. If you're represented by counsel, make sure that counsel has good malpractice insurance so that the cost of the estate can be wound up and you don't have to be personally liable if you're following advice of counsel and you do it right.
That's a wrap for today's episode of One Happy Lawyer, the estate planning podcast. If you'd like to learn more about Dan Krause and his work at Krause Estate Planning and Elder Law Center, visit estateplanningpeople.com. Thank you for listening. Be sure to like, subscribe, and come back again. We'll see you there.
Bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.